Hey, welcome back to the Cordell Cordell virtual town hall with questions I know you have. And here we're with a panel for you today to get you the answers that you're looking for. I'm Scott Trout, CEO and managing partner of Cordell Cordell, and welcome back. So today, as usual, we'll be taking some of your answers, but always keep in mind that we can't give you legal advice today. Certainly, this is going to be a directional, educational, informational conversation where we intend for you to seek counsel. We want to give you some of the talking points, some of the directions that you need to do and to have that conversation. And it can only best be had with a consultation. It's what we refer to as that kind of an initial meeting with an attorney. You can do that with us as well by going to CordellCordell.com. You can schedule right online without speaking to anyone. There's a calendar. You pick your city or you enter your zip code. It'll tell you the closest locations to you, as we have offices around the country, including the United Kingdom. So you're asking yourself, well, where do I ask the questions? In the Q&A section here, you're going to submit those. Give us your first name only. Give us a city, state, so we know if we have one of our panel members there. We can try to more redirect you appropriately. If not, we'll try to give you our best guidance as well. And certainly we probably have an office near you that we can get you to more information as well. But go ahead and submit your questions now. We have some already submitted. We'll be going through those in just a moment. But first, let me introduce our panel for today. In South Carolina, welcome Stephanie Smith.
I'm Stephanie Smith. I'm a litigation attorney in Columbia, South Carolina. I'm happy to answer your questions today.
Thanks, Stephanie. And then closing out, we also have a litigation partner, Tomekia Lee-Chaney, down in Texas. Welcome, Tomekia.
Hi, Scott. I am Tomekia Lee-Chaney. I'm a board certified family law attorney here in Texas, and I am happy to be here today.
Thanks. Well, as we said, we know you have questions. Go ahead and submit those now. We'll get those directly to those in the second half here as we're going to get through most of the questions that we have for today. We have some submitted. We'll get right to those. We want to talk a little bit also about the status of our court system. We're going to do that right after this very, very quick commercial break.
Family moments matter, even when they don't go as you planned. Cordell Cordell is a champion for fathers' rights. Kids count on fathers. Fathers can count on us.
All right, let's get right to it. I know we were talking offline, Tomekia and Stephanie, a little bit about kind of this post-COVID era. You know, we were far, far removed from 2020 and the COVID and the lockdowns and kind of the things, the unprecedented times where in my lifetime, I haven't seen anything like it, and really affected the court system, no matter where you are. I mean, we had some pockets throughout the country that almost act as if nothing had changed. But, you know, I've been doing this for 30 years, and I was mentioning to our panel that when I first started, it was not unusual for files, cases to take 3 to 5 years to get resolved. And then realizing that that was unacceptable, the court system implemented mandates to get things done. And oftentimes before COVID, it was 6 to 8 months on average. I mean, certainly less than a year, but now we're seeing that interruption. I'm sure many of you that are watching and listening may be experiencing the very same thing. So I thought it'd be good to check in and see. Tomekia, let's talk about Texas. What's going on? What's kind of the status of the court system generally? How quickly can you get into court if you need an emergency hearing? What are final hearings? How long is it taking? You know, if you haven't filed and they're watching, they kind of want to know what's anticipated.
Absolutely. So great question, Scott. Historically, the courts have always wanted to ensure that their cases were resolved within 6 months to 1 year. They have a rotating docket to ensure that if cases aren't resolved, they will dismiss it as though it was never filed. Well, unfortunately, due to COVID, the courts are backlogged with cases. And because of that reason, now more people are seeking to resolve their cases outside of court instead of in the court system, because the time frame has now doubled in the court systems here in Texas. And there have been occasions where there are new courts that are being established to kind of take up some of the backlog, but it's just not as quickly as it should be in terms of ensuring that parties are able to resolve their matters quickly as possible.
So, you know, you mentioned kind of using resources outside of court, which I back, I would say late 2020 with one of our other litigation partners, Jonathan Wynn, who was using mediation and retired judges to hear matters in an expedited manner. Is that happening in South Carolina, Stephanie? Are you seeing any kind of use of mediation or arbitration or retired judges to help facilitate the speed of getting to a resolution?
Yes, we do it quite frequently, actually. We do pre-litigation mediation, or we, after filing, try to get in with the mediator as soon as possible. At our temporary hearings that are usually held within 4 weeks of filing, we go ahead and get it in a court order when it needs to be scheduled, so we can get that out of the way. One of the issues in South Carolina is during the COVID times, there was an administrative order brought down by the Supreme Court that stayed our dismissing cases prior to their year deadline. So before, you had a year to litigate. If you didn't request a final hearing prior to then, it would be dismissed. Well, that rule was stayed. And so we now have a host of backlog cases that would have been resolved back in 2020 and 2021. And they're now getting priority in 2022. But we're ready to go on our 2022 cases. So we are enlisting former family court judges. They are booked up to February. There are several of them, but they are highly successful mediations. I would say 95% of the time here in South Carolina, with resolving issues without having to go to a trial.
Yeah. I mean, I think it's certainly an option. And if you're watching and you haven't been afforded that and that conversation, we do it a lot here in Missouri as well. I think these are typically, we're looking at judges who were in the family court system, have a lot of experience, and we actually have some predictability, meaning that we've been practicing before them for years and years and years. And given particularly even issues regarding maintenance in Missouri, there's no formula. So we have a pretty good idea in which direction they'll go. Obviously, there's some, factual differences, but I think it's a really good resource to consider, especially like I was just mentioning, I have a case that was filed, I think it was December of 2020. And now here we're coming up on the 2-year mark. We're not even set for trial yet. It just continues to drag on, and the stress load is just got to be immense for the clients. So Stephanie, in terms of the speed in which you can get to court, if you have an emergency motion, you want to get someone out of the house, or they're not sharing the bills, or there's a custody issue, are you able to get to court on a temporary, what we would call a pendite lite motion, or something, temporary custody or support motion?
Yes, it varies county to county, but it's mostly consistent throughout the state. If you file for emergency relief and it's merited per a judge reviewing it, you can get into court within 24 to 48 hours of filing. If it's expedited, 72 hours. And then if they just grant you a temporary hearing, which you can request one no matter what in any family court action you file, it'll be within 4 to 8 weeks that it's scheduled, but closer to the 4-week side of things, which really helps move things along.
Yeah. What's going on in Tomekia in terms of Texas? Are you seeing the same thing in terms of your ability in order to get to court on temporary motions?
Absolutely. So historically, it's been at least 2 to 3 to 4 weeks before you can get into court for a hearing. With a restraining order request, with an affidavit attached, making certain allegations, it's guaranteed that you can get into court within 14 days. However, what I've seen since the pandemic is that you get into court in those 14-day time period, and unfortunately that hearing is being extended for another 14 days because the court just doesn't have the availability to be able to hear that case at that particular time. So the hearings are definitely being delayed.
So I think that as we talk about it, why I thought it was good before we get to the questions to talk about this topic is there are solutions, and it's not just let's wait. I think considering your options, considering an ex-judge, considering a mediator, considering alternatives to try to find resolution much sooner. I mean, you look at things, there are a whole host of reasons why I would do it. If the economy is going to get better, your wages are going to go up, you might as well resolve it now. Those are things to consider. So get a consultation with an attorney who practices exclusively in this area. And I think that's kind of where I think the direction I would take you in. So let's just get right to some of the questions that have been submitted. And keep in mind, if you're watching right now or listening, submit your questions in the Q&A section right now. First name, state, and we'll get to those. So Tomekia, let me come to you. This is right out of Texas. Tony says, what should I do if the mother of my children is threatening to call CPS, Child Protective Services, even though my kids are healthy and safe when they are with me?
So great question. I would say initially you need to consult with one of the attorneys in the county in which you reside or where your children reside in Texas. That's first and foremost. It's important to note that whenever someone makes a false claim to Child Protective Services, that person can be charged with a felony. So it becomes a criminal matter, number one. Number two, that parent can lose visitation rights to that child or those children. And so it's imperative to know what your rights are by consulting with an attorney in your area to ensure that you're getting the documentation and the evidence needed so that you are prepared to present that to your family law attorney and or to the district attorney's office regarding the criminal aspect.
Yeah, I can tell you, we've had this question before, and I've had clients who really felt like, oh, I can handle this meeting on my own if CPS comes to the door or has a conversation with me. And I kind of cringe at times. I don't know how you all feel. Missouri, they tend to make some of their own rules as they go along. And I feel like there's so much at stake. When you get an administrative agency involved, trying to undo that can be very, very difficult. So I can't imagine ever recommending, I have nothing to hide. Go have a go with it, right? You wouldn't want to do that.
Absolutely not at all.
Yeah.
I always
Right.
tell parties, let's schedule a time so that the investigator can meet with myself and you directly. I meet with you in advance so that I can understand the background and the information, and you're adequately prepared before you meet with the investigator. Yeah,
absolutely. And I think gathering some of the records, gathering the conversations, the texts, the emails, whatever it may be, and presenting that to your attorney and having an appointment as quickly as possible is key. All right. Stephanie Garrett says, I'm moving out of my current state this month. My ex, with whom I share custody, has been aware of this and supportive. She agreed to a new parenting plan. We never got around to a custody modification, however, and she is now threatening to take my child from me. What can I do? So typical relocation question about what do you do when, in terms of sharing custody, whether Garrett didn't really say whether it's 50-50 or what state necessarily Garrett's in, but we can talk generally about South Carolina, their relocation provisions and what is required and what you should be doing.
Sure. And so it really would depend, and I hate giving the it depends answer, but I'll do my best to elaborate on what kind of visitation arrangement each of you have, what is the distance you're moving from the mother of the children. So can your current visitation schedule be accomplished? I'm assuming not. Is there anything in your prior order that states that you must notify her within a certain amount of distance of relocating? So really consulting with your prior order and consulting with an attorney in your state is highly important, because there may be something in there you're missing. You're not realizing a step that you're missing. But usually here in South Carolina, there will be a provision stating that you need to notify the parent of the relocation. If you're the primary parent, the children are going with you. However, it gives the other party the opportunity at that point to file something to stop you. So it just really depends on if you're the primary parent, if you have the right to relocate with the children, what kind of notice that you have to give. So if there's any way to provide follow-up details, I can give a better answer. But relocation cases are going to be, generally, you have to prove that the move is better for the children, economically improved, that the parent moving with the children can facilitate a positive relationship with the long distance parent now, encourage the communication. So you would establish a history of showing I'm a good co-parent. I encourage and foster a relationship with the other parent and the children. I'm not taking these children to another state and they're never going to see their mother again. Mm-hmm. Where we are going now, the schools are better. Little Johnny's a star football player, and they have the best football team in the United States. And, all of those things that are going to be viewed as in the best interest of the children, along with making sure that the children can have a positive, close relationship, and that you as the primary parent can facilitate that.
Yeah. The relocation has evolved over many, many years. When it first came out, and I know I took a case in the Court of Appeals, and you're right, the issue is the benefit of the child or children, not just because I want to move to New York. And there was a case I had taken up in the Court of Appeals where we had won at the trial level, and they actually had appealed, and that we were able to stop the relocation. And the alternative is you can go ahead and move, but the children stay here. And that's key. And I know in Missouri, there are particular relocation notification requirements and have to be done in writing for your protection. And always in custody modifications, I like to get those done and taken care of by a court order rather than just an oral agreement. And obviously, this is an example that Garrett said. Now she's threatening to take my child because she's changed her mind. So in Texas, Tomekia, what are the rules regarding relocation? How are they any different?
Yeah, great question. So since the pandemic, some of the courts have become a little bit more lax in allowing parties to relocate outside of the geographical area due to work and so forth. And so I always tell people, if at all possible, I think it's advisable for you to at least consider during the time in which you're entering orders with the court to have something put in place that specifies either travel provisions, costs related to travel in terms of people moving outside of the area, extending the relocation area to maybe a county over or a couple of counties over, so that you're not in a situation where you're faced with having the ability to move and moving, but now your possession schedule is in that same area and it's not been addressed in your order. So it's definitely advisable to prepare and pre-plan for those types of situations, including child support. You can also ask the court to reduce and offset child support based on those travel provisions as it relates to a party moving outside of the area as well.
Yeah. So Garrett, I think as we close that topic is really take a peek at your judgment. There should be a relocation or parenting plan, some notification provisions, whether you've complied with those before you move, and get to an attorney as quickly as possible to make sure that you've done everything you can correctly and that you're on good ground, if anything, before you move and perhaps create more damage long-term in terms of your custody plan. So Tomekia, come back to you. Joe says, my wife and I are getting divorced in the state of Pennsylvania.
Okay.
I make $65,000 per year gross. My wife makes around $95,000 per year gross. What are the chances I get alimony from my soon-to-be ex-wife, or is it just used to offset child support payments since she has primary custody?
Great question. So as a disclaimer, I am only licensed to practice in Texas. And so what I can tell you that you definitely need to consider consulting with an attorney in your state, in the county where you are, so that you can get the proper advice as it relates to this particular situation. But I can tell you as it relates to Texas law, so you have to consider what are the grounds for receiving spousal support. So in Texas is not like, I would say, California. I've heard about California laws as it relates to spousal support being awarded to allow parties to maintain the same level of income that they had during the marriage after the marriage is dissolved. Texas is not one of those states. So Texas provides spousal support based on certain circumstances. And that means that you and your spouse need to have been married for at least 10 years. You're unable to meet your minimum reasonable living needs, so on and so forth. And so it sounds like, just based on the general terms that you've said, it doesn't appear as though you would qualify for spousal support in this instance, just because your income is about $25,000, $30,000 lower than your wife's income. And so for that reason, child support and spousal support would not be considered interchangeably in this particular situation in Texas.
Stephanie, how does South Carolina differ on alimony?
It's similar with the not offsetting child support. However, it depends on a few things. If adultery is it, so if the offending party committing adultery, I don't care if she makes $300,000 a year, it's a complete bar to alimony in the state of South Carolina. Again, I'm not sure if that's the case in Pennsylvania. You need to consult someone. But there are probably 15 to 17 different factors to which the court looks. So it's not just the disparity in income. It's going to be the need of a spouse versus the ability of the other spouse to pay. And again, taking into consideration living expenses, if there's a large accumulation of debt that one party owes in his or her name over the other, length of marriage, tax consequences. There's just so much involved in doing that analysis. But it starts off with, in the state of South Carolina, the need of a party versus the ability of the other. And again, if there's any adultery at play, it's a complete bar, no matter how bad you need it.
Yeah. You know, even in Missouri, there's no maintenance calculation. And even in that disparity, it depends on the county. If you go 15 miles from where I am, the 65-95 split would probably wind up with some maintenance. It's really interesting. Now, that maintenance gets added into the child support calculation and deducted. So there is kind of these, it's an odd, I would not really call it an offset, but it's a calculation of the child support based upon more income coming in the door. But if you were to take the same facts to the same judge 10 times, you may get 10 different results, just because there is no formula in Missouri. And it is really factually based. And we don't have, unfortunately, like I think it's Georgia and South Carolina have that bar to alimony if there's provable, verifiable misconduct, which I think is excellent. It does come into play in terms of whether or not, but it's not necessarily a bar here in Missouri. So definitely, Joe, it's one of those where you want to get toward one of our offices in Pennsylvania and have a conversation and talk through it with that and see what your options are. All right, Stephanie, California custody situation. Obviously, we don't have one of our California lawyers here, but 50-50 custody agreement. In the 3 months since we've split, I've had the kids about 70% due to her work, travel, and she came down with an illness for a few weeks. What are my options? Just value the extra time with my kids, or do I have a case for primary custody? Previously, I was primary caretaker prior to the split. So they have an agreement, 50-50 agreement. I'm imagining it's already filed or not, but what really options do you have if over time you've creeped from 50 to 75%?
That's a great question. One that I get presented with pretty frequently in my state, and I would presume across the board that would qualify for a modification, which is a substantial and material change in circumstances, meaning you were operating under 50-50. That was what you contemplated, agreed to at the time the prior order was entered into. So you would have the kids 50% of the time, she would have the kids 50% of the time. Now you're shouldering 75%. And while, yes, absolutely cherish that extra time with your children, if you are doing the primary caretaking, by default, having 75% of the time, this could be a ground for modification in getting primary parenting time. It depends on how long it's going on. If it is a brief stint with travel, she was sick, this is going to be just a 6-week traveling situation that's never going to occur again, and got sick, presumably not really likely to happen again. You don't want to go gung-ho filing in on a modification only to find the court says, what were you thinking? This was just a brief thing. Enjoy the time with your children. So it really just matters if is this going to be a recurring thing? Is the schedule now changing and you're going to have them a lot more of the time? Look into whether this is a long-term thing versus a one-time anomaly and decide from there.
Yeah. And I would even go and not really sure from the way that the question was submitted, if they've split and they've just kind of had an interim agreement, what I would tell my clients typically is like, don't bring that to the attention, it's strategic, to the attention of the court yet. Let's keep great records. And by the time we get to maybe where a final is, they're still arguing for 50-50. And we can say, Judge, 50-50 really sounds great. However, let's look at the realities. I've got 70%. So really, I'm the primary parent. And so now that flips the script even on perhaps child support and just kind of this domino effect. It really depends on where you are in this, in terms of your case, whether it's final or not. If it's final, again, I think Stephanie's right. The words we use are continuing and substantial. Continuing is really not permanent, but it's 3 months is probably not necessarily enough for me to go to a judge unless something significant has changed that is likely to continue in the future. Like that work schedule is a fixed work schedule that is likely to alter what the parties had contemplated and agreed to. So it just gets a little bit more complex. It's one of those reasons where we talk about this is we want to give you kind of the direction. You need to take it a step further, have a consultation with one of our attorneys in our California office. It's the best 30 to 60 minutes that you're going to invest in trying to, either one, you decide to move forward and you have good grounds to do two, or two, you're now just laying the groundwork for a future modification, knowing what steps you need to take between now and then, what documents, what recordation, keeping good records is always a good thing. So that's kind of the best, information we can give you on that. All right, let's go. Tomekia, Mike. My wife and I are looking to divorce in Connecticut. After she got tired of going back and forth with me on a non-contested case, she hired a lawyer. The lawyer's trying to talk to my lawyer, who's only doing an uncontested case and wants $4,000 to represent me. What are my options? Is it better I pay for representation since they are seeking modifications to uncontested demands? It's really kind of the age-old question. Can I represent myself? Essentially, when for somebody who just wants to do a non-contested, that's really what it is.
Great. So my advice would be to obviously consult and retain an attorney, right? The attorney that you've retained to assist you in drafting an uncontested divorce is not the attorney who's going to assist you in preparing for any of the disputed issues unless they advise you, if you retain and pay for my services, I'll assist you further. You want to be sure that you have an attorney who's able to advise you in a settlement, because even if you retain a different attorney, that attorney can advise you in terms of a settlement. And if you can't settle, that attorney will be prepared to go to trial with you before the court. So you want to make sure that you definitely have an attorney, so that if in the event something is put into the order that you don't understand in terms of the legalese, you won't be able to undo that when your case is dissolved and over. You want to make sure you don't have any mistakes and any issues, and you can address any questions that you have with that attorney throughout the process.
Yeah. And I think timing is everything, especially, now that it's turned clearly contested. There's just no reason to continue with an attorney who's not going to advocate for you and to try to put you in the best position possible to achieve the goals that you have. It's just time to take some money, go invest it with an attorney who will represent you. And look, it still may settle. I've always talked about informal mediation with a lot of my clients. We come in, both attorneys are on the board, and we bring them in and we say, let's all get in a room, all four of us, and see what we can do. It's good use of money. Doesn't mean it's not going to settle. You just need someone to advocate for you. And clearly someone who, you've seen these flat rate divorces, non-contested divorce, people, that's all they do. They don't want to advocate. They're not going to advocate. It's not in the budget. It's not in the cost that they tell you. And that's okay. But it's just time to move on. All right. We have time, it looks like, for one more question. Stephanie, it's from Ted. My daughter just turned 19. However, she's continuing her education to be a vet, so my child support must continue. My question is, if it must continue, and if I must continue paying child support, does that mean that the parenting plan is still in place and must be followed? So I'm going to add to this. The question is should Ted be paying? That's always a question that I'll talk about in post-college. But is the parenting plan with a 19-year-old still in effect and must be followed?
That's a tough one. Child support in South Carolina typically ends when the child turns 18 or graduates high school. So I don't even know of any situation where they've paid past 18. I would certainly not think, I'm sure there are exceptions for that have been agreed upon, but the court does not have jurisdiction over your child was a minor child, giving the court jurisdiction over that child, meaning the judge could decide how parenting time would play out, et cetera. I don't see how a court could enforce a visitation agreement on an adult, because at that point she is an adult free to do what she wants to do. Your child support obligation is a little different, but I'll have to defer to Mr. Trout on that, because we don't do child support past 18 very often here.
Yeah. And I'll ask Tomekia in a minute, but I know we go to 21 as long as they're enrolled in and continuing in college. And that's why I kind of toss the question. What I like to do is, and once the child graduates high school, I often recommend to my clients, especially if the child is going away to school, is that we try to redirect the child support payments directly to the child. Especially if, for example, Ted's daughter doesn't ever come back to live with mom, and instead Ted's daughter is going to live permanently at school in an apartment. Those are expenses that should be paid with the child support. So there are a lot of options to consider. Now, she may come back during the summer months. Okay, so then perhaps there's a small nominal amount that gets paid during the school year, and then the child support payments revert. Now, it gets a little bit more complicated with the custody plan, simply because we have a 19 plus 20-year-old child. Who's going to follow a parenting plan? Not going to happen, right? So yes, the parenting plan is, quote, in effect, but in reality, no judge is going to enforce it, period. The child's just going to make their own decisions. Now, as it relates to tax deductions and sharing of expenses, certainly that's in place. But, and that's my long spiel. I'll go to Tomekia. What is Texas law as it relates to age of emancipation?
So similar to Stephanie. So when the child turns 18, the child is no longer considered a minor, which means child support may continue The law says 18 or graduate from high school, whichever occurs last. So child support may continue for another year or 2 years if that child is behind in school. But the reality is the parenting plan ceases when that child turns 18 years of age.
Yeah. And there are a few states like that. I think we may be the exception, but they have requirements of enrolling for a full-time caseload, providing grade reports to the payor spouse or payor parent, and to make sure that they're passing those grades. So they have to be reasonably progressing towards the completion of a degree. And it sounds like in Ted's daughter may be doing that. Just depends on what state Ted's in. So obviously you want to consult with an attorney, make sure you know. Just as a sidebar, I know I had a case where I took to the Supreme Court where both parents moved from the decreed state in Missouri, moved to Oklahoma and another state in which the child support emancipation laws were 18. And they tried to say, well, it's 18. Well, I wanted it to be 21. It goes by where the state and the decree was entered, uniform child support enforcement laws, those are the types of things. So a lot of things come into play, Ted. You want to just get some advice, something we can't do without knowing more about one, the decree, the divorce, what the elements are, and in terms of whether or not your daughter's full-time seeking her education. So, all right. So that's all the questions, all the time we have for today. Thank you for joining. Look forward to next month where we know we're going to do the same. You've got questions, we'll have answers. We'll give you the direction. Check us out on YouTube channel where all the virtual town halls are loaded on there. Check out our podcast as well, where we talk about spot topics for 15 to 30 minutes, as well as our new economic series with the true cost of divorce. You want to check that out. Go to our website, CordellCordell.com. You can schedule an appointment right there without talking to anybody. Obviously, if you want to, you can give us a call at 866-DADS-LAW. Otherwise, you can schedule a consult right from our website at CordellCordell.com. So until next time, have a great week.